is Mr. Hussein Haeri, and he will be giving his presentation with the title Agreed to Disagree, Consent in Investment Treaty Arbitration with ASEAN Parties. Mr. Hussein.
Thank you very much, and thank you. I'd also like to thank the conference organizers for the invitation to speak to you today. Chester spoke about the number of investment treaties internationally, over 3,000. Where does Asia sit in that? Over 1,000 of the investment treaties internationally have at least one Asian state as a party to them. What about the number of claims that have been brought? We've heard about over 600 investment treaty claims that have been brought. Interesting to note that over 80 of those have had Asian states as the respondent state party. So very much an important area, international investment arbitration for Asia. Particularly important also in the context of ASEAN, because a number of these claims have been brought not just against ASEAN states, but also, interestingly, by ASEAN investors. Now, I was asked to consider whether there was any particular feature to investment treaty arbitrations involving ASEAN state parties. And the one thread that I want to draw out through my talk is the importance of consent. The importance that the parties have actually given a tribunal jurisdiction to determine the dispute, which involves there being a qualifying investor with a qualifying investment, with an arbitration agreement, and with the right timing, in the sense that the treaty must be in place and in force at the time when the dispute arose. A treaty has often been interpreted or referred to as a disagreement reduced to writing. But the important thing is that in that treaty there has to be by the parties an agreement to disagree. In other words, jurisdiction for the tribunal. So what I'm going to do is go through a number of the cases that have involved ASEAN states, either as investors or as states, and highlight some of the issues that have come out from them, obviously in the short time that I have. So I'll begin by looking at Malaysia and investment treaties, but I'm not going to look, firstly, at the cases that have been brought against Malaysia, but rather at the claims that have been brought by Malaysian investors under investment treaties against other states. Because importantly, investment treaties are bilateral and they work both ways. And as financial flows in the world change, so too are the claims that we see changing in terms of who's bringing them. So the first investment treaty claim between the Malaysia-Chile investment treaty was by a Malaysian investor, interestingly. This was to do with the construction of a planned community near Santiago. The investor had an investment contract with the state to develop the project, and then subsequently an authority in Chile refused to give the permission for rezoning which was required for the project to proceed. Well, the Malaysian investor brought a treaty claim against the government or against Chile, represented by the government of Chile in the arbitration, arguing that it was unfair and inequitable for the right hand to give what the left hand takes. In other words, part of the state apparatus is saying yes to the project, come and invest, and then after the investment has been made, another part of the state apparatus is saying, no, you can't do this, go home. So, as a consequence of this claim, the tribunal found in favor of the Malaysian investor. They found this inconsistency was unfair and inequitable, and they awarded a sum of damages to the Malaysian investor. Another claim was brought by Telecom Malaysia against the government of Ghana. This was to do with a minority shareholding in Telecom Ghana. There was a change in government, and as so often happens with a change in government, the new government revisits previous arrangements and agreements entered into by the previous government and can sometimes cancel them. And Telecom Malaysia found itself being what it perceived to be squeezed out of their position as a minority shareholder in Telecom Ghana. Now, of course, a change in government has very big political consequences, but it doesn't affect a state's obligations under the treaty. And it's precisely in such a situation where a change in government gives rise to a change in policy that stability under treaties can become so important. Because under international law, it's the state that's responsible and not the government. And so this is exactly the sort of situation where you can have treaty protection for changes brought about by a new government if they undermine and contravene treaty standards. So in this case, the Malaysian investor, brought the claim against the government of Ghana under the investment treaty, and they had a successful settlement. Interestingly, there was much talk about who would be the first investor to bring a World Bank arbitration against China. It was a Malaysian investor. This was to do with the revocation of a lease agreement in Hainan province. Malaysia has also had some investment treaty claims that have been brought. This was a case that was brought with respect to an investment in securities on the Kuala Lumpur Stock Exchange. It was by a currency trader, and he alleged that the exchange controls in the late 1990s contravened the treaty protection. Now, the Malaysian state was successful in having this claim thrown out on the basis of a lack of jurisdiction. And it's because in this case, the treaty provided that a qualifying investment needed to be in an approved project, and this was not an investment in an approved project. So these differences in treaty language can have all the difference in terms of the consequence. And although there are 3,000 of these investment treaties, and you might say, as Mark Twain says, history doesn't repeat itself, but it does rhyme. A lot of these investment treaties, they don't repeat themselves, but they do rhyme. They have many common-looking standards, as Chester was discussing, but the distinctions here really can make all the difference. Each of these treaties is bespoke. Each of them is negotiated in a particular way, and in this case, this provision that defined the investment in this way resulted in a lack of jurisdiction. The MHS case against Malaysia, this was a case that I was involved with for the government of Malaysia. This was a claim regarding a contract to salvage a vessel called the Diana, which had sunk off the coast of Malacca in the early 19th century. And there was a dispute between the claimant, which was the salvage company, and the government of Malaysia with respect to payment, and an investment treaty arbitration claim was brought. The investment treaty tribunal initially found that there was no investment, that the salvage contract was not an investment, and the tribunal reached that conclusion based on looking at the criteria for so-called objective criteria for an investment under ICSID, under the World Bank Arbitration Center, set out in a famous case referred to as the Salini test. And in this case, the tribunal said there was no jurisdiction because, although it wasn't convinced that the general features of an investment were met, there was certainly, so the tribunal found, no contribution to the economic development of Malaysia from this project, and on that basis, the tribunal rejected jurisdiction. Now, this was challenged in an ICSID ad hoc annulment committee case, and in this case, the ad hoc committee set aside the underlying award, finding that the investment treaty did define an investment broadly enough to capture the contract, because a contract was an asset, and it said that the focus ought to be on the underlying investment treaty rather than on these objective criteria, and it questioned and doubted that you needed to have a significant contribution to the economic development of a state for there to be a qualifying investment. So the upshot of this was that the underlying award was set aside, and there was a finding that the tribunal had exceeded its jurisdiction. Indonesia has had some investment treaty claims recently. One of them was by an individual investor, Mr. Rizvi, who was a shareholder in Bank Century. In this case, again, the devil in the detail, the tribunal did not accept jurisdiction because the specific treaty language meant that the investment would only be protected under the treaty if it was granted admission in accordance with the Foreign Capital Investment Law. And in this case, the shareholder couldn't demonstrate that he had received this permission, and therefore there was no finding of jurisdiction. The tribunal rejected jurisdiction. So I sometimes have investor clients who come to me. I do work for governments as well, but sometimes I have investor clients. They come to me and they say, well, we've had an interference with our investment, but it's all fine. We're sure you can help because we know there's an investment treaty. And I say, well, let's see what the investment treaty says. How does it define investor? How does it define investment? Because if it defines investment in a way that you haven't complied with, then there won't be a basis for jurisdiction. So the question is not, is there a treaty? The question is, does this treaty apply to you as a qualifying investor with a qualifying investment, and does it give you the protection that you would need? Another case that was brought against Indonesia recently, the El Warak case. This is very interesting in that it was under a multilateral investment treaty, the Organization of the Islamic Conference. In this case, the investor was also a shareholder in Bank Century. He was convicted in absentia to do with alleged irregularities in Indonesia. The tribunal found that there had been unfair treatment of the investor by this conviction in absentia on the basis there had not been, according to the tribunal, due process, but the investor was denied jurisdiction on the basis that essentially he was found not to have clean hands in the context of a provision in the treaty which stated explicitly that the investor shall be bound by the laws and regulations in force in the state. So there was no entitlement to damages in this case, even though there was a finding of an effective violation of the treaty. So always important to assess the particular treaty language and how it can be interpreted, because it makes all the difference. Churchill Mining in Indonesia is a very interesting case. Chester was referring to it earlier in a conversation that we were having, because this treaty had language for arbitration that said that Indonesia shall assent to any request for conciliation or arbitration. And the interesting thing there is the question of whether that's an agreement to arbitrate or an agreement to agree to arbitrate. In other words, is it just an agreement to agree, which wouldn't get you where you needed to be in terms of a valid and binding arbitration clause. Ultimately, the tribunal did find that they had arbitration, that there was a jurisdiction for arbitration under this clause. The fact pattern was to do with a exploitation license in coal mining in Indonesia. That license was revoked by the state authorities. There was a challenge to that in the local courts. The local courts sided with the authority of the state that had revoked the license, and the investor was bringing a claim saying that this is expropriatory. Of course, the state is responsible not just for the actions of the government, but in international law, also the legislature, also the courts, and I've done a number of cases involving state interference by courts. This is a situation where court action is relevant. The merits of the case have yet to be determined, but the jurisdiction has been accepted by the tribunal. Philippines has had a number of investment treaty claims. The SGS case is one that's very famous, very well known. It was to do with import supervision services, to do with a contract between SGS and the Philippines. In this case, there was a claim relating to a lack of a payment of amounts that SGS said were due under the contract. The contract provided for court jurisdiction in Manila. But an investment treaty claim was brought with the allegation that it was unfair and inequitable for the state not to comply with its obligations under the contract and to make the payment. Now, in this case, interestingly, the tribunal said that they had jurisdiction to hear the case, but it wasn't admissible because the investor hadn't complied with their obligations under the contract in terms of the dispute resolution provisions. So the case was stayed, and I believe it was ultimately settled. Fraport in Philippines is an interesting case. This was to do with the construction and operation of an airport terminal in Manila. Some of you may know that in the Philippines Constitution there is a provision that ensures that operations of public utilities have to be done by either Philippine citizens or by corporations that have at least a 60% shareholding by Philippine individuals or companies. And in this case, the German investor had a number of shareholder agreements which circumvented not just that provision of the Constitution, but also an anti-dummy law that exists in the Philippines to prevent precisely this sort of circumvention that took place here. So the tribunal found that there was no investment in accordance with the law because the investment, quote unquote, had been made in a way that contravened these fundamental provisions of Philippines law. So there was no jurisdiction because there was no qualifying investment under the treaty. Again, going back to this importance of getting jurisdictional position right. That decision was annulled by an ad hoc committee based on an issue of not having put new evidence that arose to light very late in the proceedings to both parties. But it came again to another award by a new ICSID tribunal, so snakes and ladders, if you like, but the new tribunal found essentially in the same way as the first tribunal had, which was that the arbitration offer in the treaty only applied to a lawfully made investment, and because this investment, so the tribunal found, had not been made lawfully, there was no jurisdiction to hear the case. Thailand, this is an interesting case brought again by a German investor. They had a 10% shareholding in a concession contract for the toll road between the airport and Bangkok. And in this case, there was a contract that required the permission of the state in order to increase charges for the toll road. And the state refused to increase charges on a number of occasions. And so the investor brought an investment treaty claim saying that it was unfair and inequitable because they had a legitimate expectation to a reasonable return on their investment. And the tribunal agreed. They found that this was a breach of the treaty, and they awarded about $30 million in damages to the investor as a result. Now, another interesting thing about this case is that there was another investment treaty that could have applied. It related to an earlier period in the investment, but that earlier investment treaty had no investor-state arbitration provision. And so again, it comes back to the question of not is there a treaty, but does this treaty apply, and does it give me as an investor the rights that I would expect and would need? So because that earlier treaty had no investor-state dispute resolution provision, there were substantive obligations on the state, but no way for the investor to actually vindicate and enforce those rights. So this is an important thing, of course, to ensure from an investor's perspective they get right. Laos and investment treaties, recent case by Sanam, and this is an interesting one in the gaming sector. And there was a question about whether the PRC Laos investment treaty applied to Macau. There was also an issue around the scope of the arbitration agreement and discussion on that. The tribunal took jurisdiction over this case, finding that the PRC Laos investment treaty did indeed apply to Macau, where the investor had invested from. But the Singapore High Court actually set that award aside, finding that the PRC Laos investment treaty did not, in fact, extend to Macau, and also made some obvious statements about the scope of the arbitration agreement. Now, this is, I think, particularly interesting because the investor on this project had also incorporated a company in Aruba in the Dutch Antilles, which has the benefit of the Netherlands-Laos investment treaty. Now, this company was incorporated, if you see on the timeline, in 2012. The initial company to invest was incorporated in 2005 in Macau, and in 2009 there was a flat tax agreement that was entered into with the investor. So they expected that they were going to be taxed at this flat rate. In 2011, a new tax code was introduced, which was to impose a tax of 80% on casino revenues. So potentially very significant if that were to apply to the investor. At that point, the investor incorporated a company in Aruba, in the Dutch Antilles, which has the benefit of the investment treaty. In March 2012, a couple of months later, the negotiations with Laos, between the investor and Laos, for the renewal of the flat tax agreement broke down. And very soon afterwards, just 1 month later, in April 2012, there was an enormous tax claim and audit that was imposed on the investor. So the investor brought a treaty claim under the Netherlands investment treaty. Of course, we've just seen that the Singapore High Court found that the PRC Laos investment treaty doesn't apply to Macau, so there was no jurisdiction for the Macau entity. But in this case, the treaty tribunal found that the dispute didn't arise until January 2012 when the negotiations broke down. The dispute didn't arise until March 2012 when the negotiations broke down, and there was no legal dispute in January 2012 when the Netherlands company was incorporated. So the tribunal took jurisdiction, and merits is still to be determined. But the important thing about this case, I think, is it highlights the importance of timing and having an investment treaty before a dispute arises, because of the inability to claim retroactively under an investment treaty. Singaporean investors have also been exercising investment treaty claims. We heard, interestingly, some very interesting hypotheticals about Singapore, China. Singaporean investors brought a claim against Myanmar to do with an investment in a beer factory in Mandalay In that case, they were alleging that there was a seizure of the brewery and also that their bank accounts had been frozen, and they claimed under the ASEAN Agreement of 1987, to which Myanmar had acceded in 1997. Again, so important, the nuances in the language, the small words that might seem like they make no difference, but they make all the difference in the end. In this case, the tribunal found that because in the ASEAN agreement, it only applied to investments specifically approved in writing and registered by the host country, that there was no jurisdiction here. Now, the investor had received an approval for this investment prior to the investment treaty coming into force, but they hadn't received an approval after 1997 when the treaty came into force for Myanmar, and as a result the tribunal found no jurisdiction. Vietnam, I won't go through in detail, but a number of recent cases have been brought against Vietnam under investment treaties, again, this is part of the story of investment treaties in ASEAN, both by investors from ASEAN and also claims against ASEAN member states. So happy to take any questions later if you have any. Thank you.
Thank you very much.